Welcome. This is Political Empire. I'm Jeff Horseman for the Press Enterprise and PE.com. Today we're going to be talking about a new idea to honor Riverside's former mayor, as well as what's going on politically in the world of medical marijuana. So first, the name of retired Riverside Mayor Ron Loveridge, who held elected office in the city for more than 3 decades, could adorn a block lawn segment of the pedestrian mall in front of City Hall. The proposal to call the area Ronald O. Loveridge Plaza is the second idea from his supporters. Their first plan in 2011 to put Loveridge's name on City Hall was withdrawn after it met public opposition. Said Jim Erickson, who directs La Sierra University's Center of Philanthropy, quote, "Our feeling is that Ron advanced the city and gave it such regional and state and even national respect through his enlightened vision," unquote. Moving on, California's legislature, some 16 years after voters legalized the use of marijuana for medicinal purposes, is considering legislation that would finally impose some state regulation on its sale and distribution. Meanwhile, the California Supreme Court is expected to rule any day now on a case that could determine local government power to restrict the location of medical marijuana dispensaries. Here to talk about what's happening is Sacramento reporter Jim Miller. Jim, what's the issue and why is it taking so long for the legislature to address this?
Hey, Jeff. Well, that's a good question. I mean, like you were saying, the law, Proposition 215, was passed in 1996. And really, since then, there's just been one piece of legislation that was passed in 2003 that dealt with some of the rules and regulations on implementing Proposition 215, and really there are a lot of unanswered questions about it. Like, for example, the subject of the Supreme Court case, which is to what extent do local governments have the power to prohibit marijuana dispensaries in their communities. And as for why there has been no legislation to kind of clean things up, I think it continues to be something of a sensitive issue for lawmakers, just the association with marijuana. And then there are real disagreements on how the state should go about regulating it. Generally, on one side, you have medical marijuana advocates who I think would have concerns about excessive government regulation. And on the other side, you have a lot of people in the law enforcement community who have concerns about basically just legalized marijuana use, both medical and otherwise. So that has kind of prevented agreement in the past, and there are at least a couple bills pending in the legislature right now that at least is currently written and by design would maybe put some regulations on the books.
All right, so what does this all mean for local governments in inland Southern California?
Several of them have ordinances on the books that ban medical marijuana dispensaries, and so there's the Supreme Court ruling, and then depending on how this legislation develops, there could be state laws on the books that could impact those ordinances. I think, well, first off, everybody's waiting on the court ruling because that may make parts of the pending legislation moot or preempt parts of the legislation. So once that happens, it'll be interesting to see how the legislation develops. I think some of the opponents from law enforcement contend that any state legislation would override or potentially override local ordinances on the books. So if that's the case, then some of the ordinances in Riverside, I believe Marietta, and elsewhere that restrict medical marijuana dispensaries could those could be moot as well.
All right. Well, thank you very much for the explanation, Jim. We appreciate it. And thank you, as always, for watching Political Empire. We'll see you next time.